There are two panels of witnesses for today for our first evidence session into our inquiry on the proposed Commission on the Constitution, Rights and Democracy. And I wonder if I could ask our first panel to introduce themselves for the record, starting with Lord Sumption, please. And if I remind our witnesses that the mute function.
My name is Jonathan Sumption. I was a Justice of the Supreme Court for 7 years until my retirement 18 months ago.
Thank you. And Professor Russell, please.
Yes, I am Meg Russell. I'm the Director of the Constitution Unit, which is in the Department of Political Science at University College London.
Thank you. And Lord Lisvane.
Robert Lisvane. I retired as Clerk of the House of Commons in 2014, and I'm a crossbench member of the Lords and on the steering committee of the Constitution Reform Group.
Thank you all. Lord Sumption, the government has indicated the Commission would have extensive and a far-reaching remit. What, in your view, should be the priorities for such a Commission?
I think that the priority is to re-establish confidence in Parliament and in particular in the House of Commons. At the moment we have a parliamentary system which is parliamentary in the most fundamental possible sense. The only reason why we are a democracy at all is that the government is answerable to the House of Commons for whatever it does. At the moment, I think the main challenge is that Parliament is regarded as largely irrelevant by much of the public and on occasions by the present government. It seems to me that this is something that requires one to address three issues, only one of which is mentioned in the Conservative Party's manifesto of December 2019. The first is the electoral system, which the government is committed to retaining. The second is the procedures of the House of Commons, which have the disadvantage that almost uniquely among legislatures, the House of Commons does not have control over its own agenda. And the third is the implications of the Human Rights Act, which in some respects bypasses traditional lines of political responsibility by transferring some essentially political issues to the courts. Now, I don't know whether you want me to say any more about any of those particular matters, but those seem to me to be the headline points.
Well, Lord Sumption, just on the issue of the electoral system, why do you think that is important to be included in the consideration for a commission?
Because it determines the relationship between the electorate at large and the membership of the House of Commons. That, in the eyes of electors, is bound to be something of fairly critical importance. It's much more important to them, I would think, than the advantages of the current system, which I agree are considerable, the advantages in terms of stability and in terms of creating a decisive majority in the House of Commons when there isn't a decisive majority in the electorate at large. I regard these as very substantial advantages. But I think that in some respects, the advantages have become outweighed by the disadvantages, which are that the way in which the internal organization of political parties have developed means that there is more limited choice available to the electorate of programs than the electorate would wish.
And if I may, just on the point you made in terms of the House of Commons controlling its own agenda, as it were, is there not a distinction between government by Parliament and parliamentary government that's important to eke out, perhaps?
Yes, there is such a distinction, and I'm not suggesting that we need government by Parliament. I am suggesting that Parliament should be able to criticise effectively government policy if they think it fit. And that may enable Parliament to divert government policy. The traditional view, which is the basis of the current procedures of the House of Commons, is that the Commons is there to support the government, or alternatively, if it can't support it, to get rid of it and replace it by another which it can support. It seems to me that confining the powers, the effective powers of the House of Commons to the nuclear option is not a very satisfactory state of affairs, as we saw in the later stages of the last Parliament. Ultimately, if ministerial responsibility to Parliament is to have any real meaning, it seems to me that Parliament must be entitled from time to time to take the initiative and force a change of direction. This is something that, without bringing it into a position part of government by Parliament, is done in almost every other legislature in the world.
Thank you. I wonder if I could pose that same open question to Professor Russell, if I may. What, in your view, should be the priorities for that commission?
Well, I'm very sympathetic to what Lord Sumption was saying about the role of the House of Commons and the House of Commons' control over its own agenda. I wasn't going to say that at this point, but that's a matter that's been of great interest to me ever since before I was the Specialist Advisor to the Right Committee more than 10 years ago. And actually, we're about to publish a report on this very question of House of Commons control of agenda time. But the way that the manifesto put it, the Conservative Party was concerned about quote, the broader aspects of our constitution, the relationship between the government, Parliament and the courts. And then it went on to mention other things: royal prerogative, role of the House of Lords, access to justice, human rights. I think this is a potential opportunity to review those really big fundamental questions as addressed in the first few words there: relationship between government, Parliament and the courts. Lord Sumption is speaking to that essentially by talking about the importance of reviewing the role of Parliament. I think a lot of what's at stake at the moment is the sort of fundamental questions of the extent to which there should be constraints on the central executive, and a cynical reading of the kind of issues identified in the manifesto could be that actually what interests the government is reducing the checks on its own power, which is a source of concern. But I think it's very reasonable to stop and have a think about those big questions, about those core relationships at this time. Post-Brexit, for two reasons, really. I mean, Brexit itself, by necessity, is affecting the relationships between different institutions in the Constitution. Powers are coming back. There are questions about where those powers should lie, who should control, and what should be the checks upon them. And then the process running up to Brexit, of course, was a highly divisive one. Opinions in the public and in Parliament became very polarised. There were lots of challenges to the legitimacy and the role of different institutions, most obviously Parliament itself and the courts. And so I think this is potentially an opportunity to sit down and think about those big questions about how we want power to operate at the core of our constitution, and what the checks and balances should be. And I think that since the election and since Brexit, there have been some very big concerns about the relationship between government and Parliament, and it would be interesting to do some proper thinking about that, take some evidence on it, and take some views. I think there is a risk. It's a bit unclear. I mean, obviously the COVID crisis was an unexpected one, and I don't know to what extent that threw the government off its proposed timetable for some of these matters. We might have expected to see the Commission earlier than now if it hadn't been for the COVID crisis. In the meantime, there are all sorts of arguments going on about detailed issues. So we've seen a rather sort of scattergun set of suggestions coming out from government sources on things like moving the House of Lords to York, or abolishing certain regulators, or weakening their powers. And we've had the arguments about delegated legislation and so on, and the independent review of administrative law. So it's getting a bit messy. And it's a bit unclear whether we're going to be doing sort of piecemeal conversations about individual aspects, or whether we really ever are going to get back to those core questions about the relationship between government, parliament, the courts, the prerogative, etc.
Because I think you described this opportunity as refreshing. I'd read, and you mentioned there the extent that it could possibly go to. So, what do you think it is about this opportunity that previous constitutional considerations of the Constitution have missed or ignored? What is it about this that potentially makes it refreshing?
Well, as I say, we're in a new post-Brexit environment, and it's entirely proper to sit down and rethink how the UK constitution should work, with the removal of the kinds of constraints that previously were upon policy making as a result of being a member of the EU. But in terms of the refreshing nature, I think one of the criticisms that was famously levelled at the Labour government's constitutional reform programme, if indeed some people argued you couldn't really call it a programme, was that it was a very sort of pragmatic, piecemeal approach to different institutions. So the introduction of devolution, human rights, freedom of information, reform of the House of Lords. There was never a review sitting down thinking about the Constitution in the round and what the overall goal was and what the overall balance of power should be between different institutions. What was the principle guiding all of that? And I think it would be rather refreshing to sit down and go through that exercise now, if indeed that is what the government has planned. But as we might come on to later, I think if we're going to do that, it's important that it's a really big inclusive conversation and that we're listening to what the public thinks about those matters. It's also an opportunity, sorry, I will stop in a second. It's also an opportunity, one would hope, to rebuild public trust in our institutions, because the Brexit arguments were so divisive and there were such sort of allegations thrown left, right and centre about who was having a constitutional coup of one kind or another. To have a sort of cool-headed analysis where we involve the public in conversations about what we all want out of our constitutional arrangements, I think would be refreshing after a time of great sort of turmoil and disagreement.
Thank you for that. I wonder if I could bring in Lord Lisvane, please, with his view of what the priorities should be for said commission.
Thank you. Well, I'd start by saying I think there's a glaring omission from the agenda set out in the manifesto. You could call it an agenda. I think given events over the last couple of years, you might also see it as a hit list, and I hope it's not. But one omission is legislation and the legislative process, which frankly is a disaster area. And if the opportunity could be taken to do something about that, and of course it brings in the other themes of relations between the executive and parliament, and in terms of involving the public, then that would be very welcome. I think the daunting thing about what is proposed is the sheer size of the canvas. And as soon as you start unpacking the individual elements, they expand further. For example, how do you do government and parliament relations without looking at the devolution settlements? How do you do access to justice for, in the condescending phrase, ordinary people, without looking at the structure and resourcing of the justice system and legal aid? So as soon as you start looking in more detail, the sheer size of the task starts to increase. And I think that that is going to be a major challenge if it is set up in the way that seems likely.
And just in your own words, sort of expanding perhaps on the, I think I quote you correctly, say legislative process is a disaster area. What do you mean by that, Lord Lisvane?
I mean the way that legislation is conceived and brought forward and the way that it's scrutinised, and the very bad habits that successive executives, but it's now reached a pretty low point, have got into in terms of providing delegated powers for ministers, very often with a low level of parliamentary scrutiny. I would like to see the killing off of Henry VIII powers, which are really, I would say they're anti-democratic in the way that they are used. The temptation of skeleton bills, which increasingly governments cannot resist, and also the way in which legislation is scrutinized. You know, we have this comfortable phrase, line by line scrutiny. It really doesn't exist. Even in the House of Lords, it doesn't exist. Of course, the perfunctory way that the Commons often deals with legislation casts the House of Lords legislative process in a rather more complementary light, but there are still major improvements that could be made.
So could that be done by perhaps improving the quality of members of Parliament then?
Well, you take me down a road that I would not wish to travel.
I think that's very diplomatic at this juncture. Could I go to Meg Russell, you indicated there?
Yeah, I'd just like to echo one of the things that Lord Lisvane said there, or maybe two of them. I completely agree with him about delegated legislation, but it is an absolutely glaring omission from the implied terms of reference in the manifesto that devolution is not mentioned at all, the devolution settlement. And I think that's completely inseparable from these other wider questions about balance of powers and constraints on the central executive. And obviously it's hugely controversial at the moment. Devolution is discussed in the manifesto, but it's not on page 48. Which I thought was quite strange, because if we're looking at fundamental relationships, you can't avoid discussing that.
Thank you. I bring my colleague John Stevenson in here, if I may.
Thank you, Chair. It's really interesting that you've all concentrated on the House of Commons as one of the priorities rather than other aspects of our Constitution. And indeed, I have a lot of sympathy with what has been said, particularly regarding secondary legislation. But I just wondered, are you going down a route that we should be seeking a much more formal separation of powers between executive, legislature and the judiciary? And I just wondered if that's the route that you would like us as a country to go down. If I start with Lord Sumption.
No, for my part, I am not. I think that there is already a complete separation of powers between the judiciary and the other two branches of the state. There has never been a complete separation between the executive and Parliament, and I would not for one moment recommend that there should be. I think that the fact that ministers are members of Parliament, and the more important ministers of the House of Commons, is an important and valuable thing. But it accentuates the importance of enabling the House of Commons as a body to control and occasionally to limit what the executive is doing.
Thank you. Lord Lisvane, given what you've just said about the legislature, the legislation procedures that we have, what would you say about our greater separation of powers or greater independence for Parliament to do its job?
Well, I agree with Lord Sumption, but of course, lying behind this concept of the independence of Parliament is the party system and the whips. It is interesting that the shortfall that I described and which Professor Russell has described, you don't need to develop great sophisticated structures. It can be done by behavioral change, but of course a government has to accept a different way of doing business if we're talking about legislation.
Okay. Professor Russell?
I'm inclined to agree with the other two witnesses, really. I tend to be a supporter of the political rather than the legal constitution. I suppose there is a question about what you're trying to separate from what. And if you're trying to separate government from parliament more, i.e. move to something more like a presidential system, I'm also not a supporter of that. I agree that government accountability to parliament is a core part of how our system has tended to be stable in the past, but the constraints are often political rather than legal. And I think that that has actually not been working very well recently. We seem to have moved to a system, due to all the acrimony over Brexit and the coming together of that with a minority government, to a system where I think sometimes the government has looked resentful of the fact that it is actually accountable to Parliament, and what you need is to reach political agreement with Parliament in order to get your programme as government. You shouldn't be seeking to go to war with Parliament. I think we've seen rather too much of that recently, and we'd see a lot more of it if we had a separation of powers system. They're a lot more adversarial than our system, but they don't necessarily function better. I think what we need to get back to is the better functioning of the system that we've already got, of the understanding of government's accountability to Parliament and Parliament's role, and Parliament being let back into decision making a bit more. And I think that the issue, I'm sorry to go back to it, but of the House of Commons' control of its agenda, there is a place perhaps where we could have a bit more separation, as in government has too much power over that. And I think that under the minority government situation last year caused a lot of difficulties, because the majority of MPs were not able to get onto the agenda what they wanted. And arguably we're seeing that now even under majority government with, for example, the Brady Amendment last week.
Thank you. Thank you very much. Could I go to Lloyd Russell-Moyle, please? Lloyd.
Lizveen, you mentioned about scrutiny of bills. In the US, for example, in other systems, select committees are also the committees that do the bill scrutiny. So you develop members who have expertise in that area. Is that an area that we should also be looking at in terms of kind of the expertise you garner with your members, so they're able to hold the government to account better or not?
Yes, I think only up to a point. I wouldn't give departmental select committees, for example, a role in legislation, because I think you risk diverting. There are only so many hours in the day and days in the week, and I think you risk diverting resource from calling the government to account in terms of policy audit and so on, and legislation. If there is to be a select committee involvement in legislation, then the time-honoured possibility of committing a bill to a select committee or a joint committee, so that you don't have double handling as between the two houses, is something which I would like to see revived as a fairly regular process. And that has lots of advantages, because you're talking to people, you're taking evidence from people who really know about the subject or people who are going to be affected. And it also reestablishes a link between Parliament and the public, because it is something which is open to outside contributions in the way that proceedings on the floor of the House or in standing committee simply aren't. I mean, it is possibly unattractive for a government, but I think it is something that ought to be front and centre of the way we look at legislation. Could I just add, following on from what Professor Russell said about, I mean, the whole question of a votable agenda has been floating around for years. I mean, it's a bit of a veil of tears. And the first faltering steps towards it were with the Backbench Business Committee. But that actually laid bare something which is at the heart of the relationship between the executive and Parliament, because you get the House agreeing to a motion which has been brought forward via the Backbench Business Committee. And the government says, oh, well, that's frightfully interesting, but actually, we're not going to do that at all. Now, that seems to me to call into question in a rather fundamental way, what is the relationship between the executive and Parliament, and particularly in this case, the House of Commons?
Lloyd, did you want to follow on? I think Professor Russell would like to come up at that point.
I wasn't going to go back to this. I don't want to get caught in talking about the House of Commons agenda again, but on Lloyd Russell-Moyle's original question about the role of select committees in bill scrutiny, I agree with Lord Lizveen, but this is a real dilemma. We're quite unusual in the UK in separating out bill scrutiny from executive oversight in committees. Across Europe, in the US, in other countries, you have specialist committees that do both bill scrutiny and executive oversight. And I think that the result of that is that we have poor quality bill scrutiny in committees generally, because they are temporary and non-specialist, but we have exceptionally high quality scrutiny in the select committees of the executive and of sort of longer term planning, etc., all of the things that select committees do. So I think a great deal would be lost if scrutiny of bills was brought into select committees. You'd begin to see whipping in select committees, and effectively the government would be setting the agenda of select committees because you would be in a responsive mode depending on what bills they published. But we did publish a report on this, I think it was in 2011, with the corny title Fitting the Bill, on how we could square this circle. And we made some suggestions about introducing some greater permanence and some greater expertise amongst bill committees. So I think that is an agenda worth addressing, but the answer is not to merge that scrutiny with the work of select committees for fear of spoiling, one of the best things that the House of Commons has to show the world in terms of executive accountability.
Thank you, Lloyd.
Thank you. That's good.
Lloyd, I think it's your turn again. Actually.
Question 2 now as well.
Indeed.
Yes. So, look, this for all the panel members. Maybe Lord Sumpton, you can go first. The question is: should there be a role for the public determining? And if so, how do you get the public involved, and how do you get them interested?
Well, getting them involved and getting them interested are two different things. I think it's realistic to get them interested, and I have suggested 3 areas when I spoke first, in which I think the proceedings of the House of Commons in particular, by becoming more important and more effective, would become more interesting. The fact is that by comparison with many other countries in the world, our population is particularly interested in politics. Their relative indifference to Parliament at the moment is not a reflection of their indifference to politics in general. And that is a source of real concern. But turning to the question of how to get them involved, it seems to me that this essentially turns on the relationship between members of Parliament and their constituents. I know that you are due to hear in the second session evidence about citizens' assembly, and I don't want to trespass too far on that area. But I have to say that I think that the problem about public involvement as opposed to interest is that it is very difficult to devise a system in which you can be sure that the members of the public who are expressing their views are actually representative of the public as a whole. And it seems to me that ultimately MPs who wish to be re-elected are probably a better guarantee of a broader level of sympathy for what Parliament is doing than citizens' assembly or any other kind of public involvement that I can envisage. Obviously, there's a very important place for consultation of the public because they may have views and ideas which will not have occurred spontaneously to legislators, but I cannot see it going further than that.
Is the public, is there a halfway house in this where you're talking about MPs and legislators and then layman on the or lay person on the street? Is there involvement? Is there a way that involvement of local councillors, those kind of other levels of governance, those other people who are to some extent representative should be involved in this?
I think there are many occasions when it would be right to consult exactly that kind of person, and that could happen more readily than it does now. One's talking about the consultative process.
Yes. No, thank you very much. Meg Russell.
Yes, I mean, I think we've all established that we don't really know what we're talking about here in terms of what this commission is going to be and what it's going to cover. And of course, the answer to some of these questions is very contingent on what remit it's given. But just supposing that its remit is the one that I think it ought to have, which is looking at core principles about balance of power, then I think that absolutely you have to involve the public on that. You're talking about the way that we run our democracy in a very fundamental way. And I don't see how you can legitimately change those democratic structures or make recommendations for change without knowing what the public thinks. But I also agree with some of the things that Lord Sumption has said, that can be very difficult. It mustn't just be a case of sort of who shouts loudest and special interests and so on. You have to really get a representative sense of what the public thinks, and that is hard. We've thought about this quite a lot at the Constitution Unit, and indeed we're just waiting imminently on the results of a funding decision for a project which we're hoping to do, which is all about public involvement and getting public views on this very process. If you look at standard opinion polling, you will find that the polarization of opinion in the public drives attitudes to the role of political institutions. So, for example, polling on the role of referendums, whether we ought to have more referendums. After the 2016 referendum, the number of people supporting holding more referendums quite radically dropped. But if you looked at the figures, it dropped among those people who had voted Remain, and it remained very solid amongst those people who had voted Leave. Fast forward by a year or so, when there was a lot of talk of holding a second referendum on Brexit, the overall number is fairly stable, but it shot up amongst people who voted Remain because they want a second referendum, and it has begun to slump amongst people who voted Leave because they don't want a second referendum. And that's just an illustration of how attitudes to things that ought to be principles of constitutional design get very caught up in people's attitudes to what outcome they want. So I think if you're asking the public what they want, you have to find ways of getting beyond that, which is difficult. And the two things that we're hoping to do, one is to do much more sophisticated polling than that, where you offer people different scenarios. So, it's no good saying, do you think that the government ought to have more power over Parliament? Because supporters of the current government may well say yes, while opponents may well say no. You have to say, let's suppose that X was in power, should they have more power over Parliament? Or let's suppose you don't know who's in power, etc. But even then, in polling, it's quite difficult to get at it. And therefore, the other thing that we want to do is run a citizens' assembly on these very core questions of balance of power and checks and balances on the executive, because that allows people to really begin to think in depth about these issues and place themselves in different people's shoes and see it from the point of view of other people with whom they are having discussions, who have different political opinions, come from different income brackets, live in different areas of the country. You need to come up, when you're designing a constitution, it needs to have broad-based support. It needs to be a long-term, stable settlement. It can't be about winners and losers. It needs to be about the rules of the system, which are more like the referee, which everybody thinks is fair and whose decisions everybody is prepared to accept. And there is a real danger going into this question in what is quite a polarized environment still, of changes looking like they're about winners and losers rather than about something long-term and stable for everyone. And for that, you need public opinion, but it's difficult to get. But I think it's not impossible, and we hope to do some of that.
Is that harder if you are just talking about the very top level, the relationship between national government and national parliament? Does it become easier if you start to talk about how you want principles of governance to work at the devolved level, at the local council level, at the cultural unit of a county or a town? Are the conversations easy and you start to talk about them closer to the actual people?
I think they are, and indeed the Constitution Unit was a partner on a project about 3 years ago, I think, looking at devolution in 2 local areas. And that is easier for people to get their heads around. But of course, we've already indicated this is a very wide agenda, and there are lots and lots of interlocking parts. So there are risks in breaking it down into its component parts, in not coming up with something that adds up to a coherent whole. So I think, given the arguments that we've had over the role of the House of Commons, the House of Lords, the Supreme Court, even the monarch in some of the arguments over Brexit, we do need to look at those core relationships, and everything else should flow from there.
Paul Swain, is there anything that you want to add on this question of getting the public involved and getting the public interested in these issues?
Well, just 2 things to add to what Lord Sumption and Professor Russell have said. The first is that select committees over some years now have been a success story in both houses. So the way in which they might be played into the relationship of involving the public to a greater extent is something that certainly should be on the table. The second thing is really a word of caution. When you consult people, people rather expect you to do what they've said in response. And you do risk an additional level of disengagement if consultation is not widely seen as having an effect. There's no easy way out of that, but it is something I think one needs to keep in mind.
Thank you, Lloyd. I can go.
Thank you very much.
Thank you, Lloyd. John Stevenson, please.
Thank you, Chair. Lord Lisvane, do you think the government wants the Commission to be open-minded to these issues and give it consideration, or do you think the government already has an idea of what the Commission wants to report on?
Well, I rather rudely used the term hit list earlier on, and looking at those four elements, you can see that they have, shall we say, a little bit of political antecedent about them. I think there are four tests. The government has to demonstrate that this isn't going to be a fix. And there are four tests. First of all, commissioning. What is the Commission actually going to be asked to do? And how prescriptive will those terms of reference be? Second, timescale. If the time allowed is ridiculously impractical, then the whole process is going to be inevitably superficial, and it's going to go nowhere near the profundities that we've been exploring this morning. The third is membership. Now, that clearly is going to be key. Who is on, how independent they are likely to be. And the fourth is resourcing, because if you starve it of resources, it's not going to be able to do a proper job. So I would want to see all four of those boxes ticked in order to demonstrate that it's going to be a genuinely independent exercise.
Thank you. Professor Russell?
Yes, I completely agree with that. I was just comparing Lord Lisvane's list with my list to see where I could find any points of difference. I'd written down very similar things. I think I would add to, well, I mean, in terms of the membership, it's essential that it's seen to be balanced and not a group of people who already have a fixed view, I think. And on top of the things that Lord Lisvane has mentioned, I think it needs to be committed to taking evidence and having a very open-minded attitude to evidence. That includes on public opinion, it includes on practice in other democracies, for example. And I agree that that takes time. I actually think it may be quite difficult, given the mood that we have had in the country, for a body set up by the government to be broadly trusted, because our politics has felt very, very divisive. So I think this is a really big challenge for the government, because if they set up something which isn't trusted, which is seen to be partisan or biased in some way, which is seen to be not listening broadly to the evidence, then you'll get an outcome that people don't accept, and you won't get a stable settlement as a result. I think there is an interesting question which is sort of bubbling up through this conversation as to what the role of Parliament is in this, because whilst government might not be trusted to be kind of neutral in these matters, Parliament is obviously a more plural place which represents many voices. And many of the things, you know, Lord Lisvane has referred to the select committees. The select committees in many ways are a model of doing this kind of exercise. You know, they are cross-party, they are diverse in their membership, they do take evidence, and they publish very high-quality reports. And they also, of course, are very transparent. You know, a distinction between the way that select committees work and, for example, the Independent Review of Administrative Law recently set up. I don't think that is publishing the evidence submitted to it. I don't think it's taking oral evidence. It's certainly not doing so in public. So I think there are lessons that can be learned from Parliament in doing this, but there's a bigger question as to how Parliament itself is going to be involved, and whether indeed, if the government doesn't set up a commission like this, whether Parliament might want to think about doing some work on some of these big important questions about restoring trust, etc.
Some very interesting points there. Lord Sumption.
I think that a critical, first of all, I agree with what has been said by both the other two witnesses. More specifically, I think that a lot hangs on the identity of the chairman, because the chairman will be seen as the figurehead of the commission, and it's extremely important that he should be, or he or she should be, a figure who is entirely non-political, but not politically naive or ignorant. I mean, I know that judges are not flavour of the month with the current government, but there is a lot to be said for a senior judicial figure presiding over this commission. I also think that it's important that it should have at least an element of elder statesmen with personal experience of practical political engagement, but who are out of the fray now in the sense that they are no longer members of the House of Commons, certainly, possibly of either house. Those more specific suggestions I make against the background that I entirely agree with what both the previous witnesses have said, which is that if we do not have if this commission is not seen as working for the system rather than for particular points of view, then it will fail.
Thank you.
Thank you very much indeed. If I could go now to Ronnie Cowan, please. Ronnie.
Thanks very much. I'm curious here. I mean, this commission came about through the Conservative manifesto prior to the 2019 general election, and the idea was that it was set up in its first year. In February, the Cabinet Office Minister Michael Gove said he would determine the remit, and then the 27th of February, Chloe Smith in front of this committee said full details will be announced in due course. In July, in the Conservative Home, not publication I subscribed to, suggested that the commission had been abandoned, and at the end of July, the government announced an independent review of administrative law. So, where are we now? Well, it's October. Do you have any idea what the remit is going to be? Because you've got until a couple of months' time to get this thing up and running.
Lord Sumption, would you like to take that question?
I wish I knew the answer to that question. The problem is we are being told very little. I also, for what it's worth, get the impression that the government is cooling off on this particular aspect and is trying to focus on doing down the courts as potential sources of impediments for the government's programme. I think that if they confine themselves to that, they are very unlikely to achieve much.
Meg Russell?
Yeah, I think there's a lack of clarity over the independent review on administrative law, to me. I mean, obviously the short answer is call in a minister and ask them this question, because we're not well qualified to answer it. But it seems to me that the primary driver of reading the words in the manifesto of this commission was a desire to rebalance with the role of the courts. And they now have this independent review, but it's not clear to me, having read the terms of reference of that review, whether they're expecting it to cover all of the issues of concern, particularly the issues around royal prerogative, the Miller cases, etc. That's not evidently within the terms of reference. So I'm actually genuinely unclear, wanting to express a view on those things as to whether I should be responding to this review or whether I should be waiting for the next one, because we don't know whether it's coming and we don't know what it's going to cover. At the same time, I think there are various issues that should be being thought about with urgency that are not being thought about, and there is a risk that the bigger review becomes a kind of cover for not dealing with some of those questions. So one of the things which has greatly exercised me over the years, and indeed has greatly exercised this committee in the past, is the size of the House of Lords. There's broad cross-party agreement that something needs doing about the size of the House of Lords. But we're not seeing any action on that, and indeed we just saw a large number of peerages which has breached the agreements proposed by committees in the past, backed by this committee in the past, and we're hearing talk about more appointments. So I think that there are some urgent things that we could be getting on with, and there's a danger they're being kicked into the long grass on the basis all of this is going to be part of a big review, and meanwhile there are small things coming out and we don't understand how they join up to that big thing. So please ask a minister this question.
Lord Lisvane, have you anything to add to that?
I think the discussions we've been having this morning have rather demonstrated that probably this assertion in the manifesto wasn't adequately thought about in advance. It bears all the signs to me of a Friday afternoon moment when somebody says, oh crikey, we haven't put in anything about the Constitution. So these bits get shoehorned into the manifesto. And it's only after a period of time that the reality of how big the task would be starts to bite. And that may well have been and continue to be an inhibition on ministers. There is one oddity. The review of the criminal justice system, we're told, is to be by royal commission. I'm not quite sure why it wasn't thought that this should be a royal commission, or why a royal commission was appropriate for the review of the criminal justice system. As I say, it's simply an oddity.
Very good.
Thank you very much. I want to slightly hark back to the previous question, if I may, because this is something you said there. But if we cannot define the remit for this commission, then we're going to go nowhere with it at all. Do you think maybe that was the initial intention? This was simply something which was just die on the page and go nowhere? Because one of the things in the manifesto, which opens up with a magnificent line, as Conservatives we stand for democracy and the rule of law. But it goes on to say, if the Brexit chaos continues with a second referendum and a second Scottish referendum too, they, being the people, will lose faith even further. So is the idea this just dies and goes away and the government's left to do what the government's been doing for the last 4 or 5 years? Anybody?
It might have been slightly rhetorical, that, Ronnie.
Well, I think your committee ought to be the government's conscience in this respect, if I can suggest that.
An idea floated by Mr. Paul Flynn over the number of years. Thank you very much.
Thank you ever so much, Ronnie. If I could just bring Karen Smith in briefly, please. Karen.
Thank you, Chair. Just to add, the one group that we haven't really referenced is the role of political parties in this. Democracy relies on good governance within the political parties. So, and actually all the political parties in recent years have also undergone our own, without washing all our dirty linen in public, have undergone our own internal problems. And I think that's across the board. And what's your view about how political parties contribute then to the wider commission as arbiters of political values across the country? Professor Russell, if you wanted to take that first.
That's an interesting question. One of the things that we've seen, obviously, over the last year or, several years, is enormous division within the political parties. So these divisions that we've seen over Brexit have not been between parties. They've been as much within parties, more within parties than between parties, really. So that, I suppose, illustrates that there isn't necessarily going to be a party political view on some of these matters. There's a real diversity of views. I think that a commission, it would make absolute sense for a commission to at least have some members who are or have been representatives of political parties. I think that's in line with what the other witnesses have said. But if you look back at what I think was I was wondering about royal commissions as well. I think the last royal commission that we held was the one chaired by Lord Wakeham on Lords Reform 20 years ago, which I was quite involved with. And it had party political figures on it, but it also took evidence from political parties. And I think the role of political parties probably is to submit evidence, as is the role of political party representatives individually. And as community organisations, political parties, of course, can try to play a part in involving the public, facilitating local debates, encouraging people to write in or whatever to a constitutional commission. I think that would be quite healthy. But I'm not convinced the parties are going to be in a position to take strong views on some of these issues. And actually, I think it would be a bad idea if you had a Conservative view and a Labour view and one of them won out over the other, because that would rather destroy the whole kind of sense that this needs to be a long-term settlement which works across the divide, irrespective of who is in power.
Assumption?
I understand the question to be directed not so much at the role of political parties in the working of this commission, but at the role of political parties in the functioning of the Constitution more generally.
Yes, that's also, yes.
And on that footing, I think that, if I may say so, you have put your finger on an issue which is both central and extremely sensitive. Political parties are, at the moment, the biggest interface between Parliament and the public. They have traditionally adjusted their offering in response to what they perceive to be changes of public values and changes of public opinion. They often get criticized for this, but actually it's an extraordinarily valuable and important function. And that is how the political market has traditionally worked. What has happened in the last few years, mainly as a result of the polarization of opinion on Brexit, but also other matters, is that against a background of shrinking membership rolls of all the major national parties, the constituency associations are in the hands of very small groups of people, which are very easily the subject of takeover bids. People who have the energy and time to take over a constituency association are likely to be people of especially firm views, not very sympathetic to compromise or broadening out of the political spectrum. For that reason, we have a problem that the way that political parties work now is obstructing the function of the political market and is diminishing the choices available to the public. If you have to go into the polling booth and say to yourself, which of these parties would I most hate to vote for? It seems to me that something is wrong.
If I just follow up for this, I mean, but that is the system in which the public and indeed political parties operate, as you say. And I guess the lead question is then, how do the parties themselves govern themselves in a better way in the future in order to aid the democratic process? And it's perhaps we're all coming through that difficult birth pangs of something new, I suppose. But we are where we are with political parties, so somehow we need to marry that with a desire to look further at this commission and the constitution. Professor Russell, I think you wanted to come back on that.
Yes, I'm sorry if I misunderstood the question the first time round.
I think there was a bit of both, but
yeah.
But that Lord Sumption was right about my general thrust. Yes.
On this point, I think there is an important point which I've made before in writing. Going back to the separation of powers, the way that the Labour Party in particular has worked in recent years has been rather in line with the separation of powers, in that the Labour Party has moved to a system whereby the grassroots membership can impose a leader on the parliamentary party that the parliamentary party doesn't want. And I think that's a dysfunctional situation in a parliamentary democracy, because it's Parliament that holds government to account. If that party were elected into power, it would need the confidence of the House of Commons, and that confidence of the House of Commons needs to start with its own members. So I actually think it's an untenable and very destabilising situation to have got to the point where the democratisation or the increased participation of party members in choosing leaders takes you to a parliamentary party having a leader which it does not support. The Conservative Party hasn't fallen into that trap. The Conservative members of Parliament still can vote no confidence in their leader, and they have a greater role in who gets on the ballot in the Conservative Party, and I think that's a rather better system. But I think that this question of the degree of membership involvement and what that does to the stability of parliamentary government actually is sufficiently important to be a constitutional question now.
Thank you. Just pressing on, if I may, to David Jones. David, please.
Thank you, Chairman. Could we go back to the issue of the independent review of administrative law? Professor Russell, you've pointed out your concerns about the lack of clarity in connection with its terms of reference. And this was, of course, meant to be an issue that was considered by the Commission as a whole. Do you think, however, that there is some case for separating the review of administrative law from the wider inquiry, given that there are likely to be more highly technical issues at play there?
I think I would primarily like to defer to Lord Sumption on this, but my general view is that, as I've expressed earlier, I think it's better to start with the high-level principles and then move down to the level of detail. And those high-level principles, are genuinely unclear whether they are within the terms of reference of this inquiry or not. And it seems difficult to see how a subsequent inquiry can decide the general principles if an earlier inquiry has already decided the detail. But I'd be very interested to hear what Lord Sumption says.
Certainly, but before I ask Lord Sumption, is it your view, therefore, that the Commission, the wider Commission, will still have to consider issues of administrative law, and in particular, of course, the issue of judicial review, if there is to be a serious, if it's seriously to address the relationship between government, parliament, and the courts?
Well, clearly one of the drivers of all of this is a feeling amongst at least some in government that there are some issues around the prerogative that should be taken out of the scope of judicial review. And those are very, very fundamental questions given the prorogation case. But I am unclear whether they are within the terms of reference of this review. And in a way, they feel a bit too big to be within the terms of this review. It's also a very rushed review, and it's very closed in the way that it's operating. So I think if it is asking questions as big as that, and perhaps even the questions it's asking deserve more time and more transparency. But I think that the questions around the Miller cases and so on are absolutely fundamental constitutional questions, which probably belong somewhere else, but I'm not clear what the government's intention is.
Thank you. Lord Sumption.
I think that the title of the Independent Review of Administrative Law is, in a sense, something of a giveaway. Describing it as administrative law is not really accurate. Judicial review is concerned with administration at one level, but also with constitutional issues, because in the absence of a written constitution, we have a constitution which is in part governed by common law principles. And those principles are naturally principles that would fall to be applied by courts of common law. I think it's a mistake to try and separate out judicial review generally from the other constitutional issues, because judicial review at the moment is one of the two major ways, the other being parliamentary scrutiny, in which governments can be kept within their proper function. I don't think that anybody is suggesting that simply because there is a large political element in a particular judicial decision, it shouldn't matter whether the government exceeds its powers or behaves in a way that is unlawful. So you have to preserve some system for ensuring that the courts are able to do that. Now, that clearly does have major constitutional implications, which are very difficult to separate from the broader constitutional issues that we have been discussing to date. The big practical problem is that there isn't a single rule of law which can be amended or abolished so as to change the situation. The current differences between the judiciary and the government really arise from a judicial culture and a series of judicial attitudes to government which have built up in the case law over a period of 50 or 60 years and are deeply ingrained in the way that the courts operate. For that reason, I think that the only practical way of actually dealing with this issue, and I think it's an important issue on which I've got some sympathy for the government's position, the only way of dealing with it is, in fact, to codify and rewrite the whole of English administrative law. I don't think that that is going to be an easy thing to do, and I don't suppose that it's going to commend itself to the government. But that simply underlines the difficulty of what it's trying to do. Without actually rewriting the whole of English administrative law, you are not going to alter attitudes which I think the government is right in thinking have occasionally trespassed from strictly legal issues to purely political ones. There isn't a neat boundary line between those two things, but there is a broad band which separates the two, and I think one needs to recognize that.
Clearly, the review that has been launched is insufficient in terms of time, and I would suggest also in terms of remit to consider the wide review that you have just suggested.
Yes.
Lord Lisvane.
Thank you very much. I would, on the 31st of July, the government said that the panel would report back later in the year. And the opening statement by the distinguished chair of the review said that it was going to be an examination of the need to strike a balance between the right of citizens to challenge government through the courts and the elected government's right to govern. Now, that second limb, I think, demonstrates what a huge task the review has in a very short period of time. And whatever they come up with, it will be very difficult for the Commission that we've been discussing entirely to ignore that or to contradict it. And I think that's a recipe for unconstructive confusion.
So what do you think that this committee and other committees should be doing to monitor that review?
Like, I would hardly hardly write your agenda for you, but
I'm sure we'd all be very willing to listen to your advice, though, Lord Lisvane.
Well, you're much too kind. It depends on what degree of transparency the review is actually going to involve. Now, if it's going to do the task that quickly, then having a reflective means of making progress, taking evidence, and things of that sort is going to be much more difficult the shorter the time which is available. So I think your opportunities for monitoring what it is going to do are going to be pretty limited.
Lord Sumption?
Well, I mean, I agree with what's been said about the extraordinarily short time. I think that the government has simply completely underestimated the scale of what is involved if it's going to achieve anything. If the object of this commission is to use the phrase used earlier about a hit list, simply to knock out the courts from reviewing the lawfulness of government acts that have large political implications, it probably won't take very long, but will be extremely controversial. If the object is to deal with the problem as a whole, and it's a complicated problem, then it's going to need a lot longer than it's got and a lot greater input from interested and expert parties.
Professor Russell, do you agree?
Yes, and I think that it is a very difficult question that you're asking and a difficult position that you're in, but I think the key word is probably transparency. You can bring some transparency to the process, and you can do so not only as a committee through calling people in, but potentially through, for example, parliamentary questions. I'm not sure how much the government will give away about who's submitted evidence, how many people have submitted evidence, the timetable, and so on. I mean, there's a vast range of possibilities in terms of transparency, everything from probably at one end a Royal Commission to at the other end, for example, the Strathclyde review on the powers of the House of Lords, which happened a few years ago, which was a government review and issued a report and recommendations. I gave evidence to that review. I went to the Cabinet Office and I met Lord Strathclyde and his civil servants, and we had a long conversation. My name doesn't appear anywhere in that report. I mean, we have no idea who the witnesses were. That's the extreme of lack of transparency. I can imagine Lord Lisvane may well have given evidence as well. So if you can make this process more transparent than that, that would be some kind of an achievement, although it might not get you to exactly where you'd like to be.
Thank you.
Thank you, David. Tom Randall, please.
Thank you, Chairman. One of the themes of the discussion so far is one of public trust in the political institutions and UK democracy. I wondered what the panel's view is on, and the government itself has said the Commission should try to restore trust in political institutions. I wondered what the panel's view was on whether, do they think there is significantly less trust in public institutions now than there has been in the past, or is it a case that there is, nostalgia is not what it used to be? And if so, how can the government best set about re-establishing that trust? Perhaps Lord Sumption first.
Well, I think that there is less trust. I think that one shouldn't generalize too much from the remarkable circumstances of the last 3 years over Brexit. But for very many years, surveys such as the extremely interesting and helpful surveys of political engagement conducted by the Hansard Society have indicated a decline in public trust. And also, it has to be said, I say this with dismay, an increasing appetite among the public for more authoritarian models of government. My own view is that authoritarian models of government are extraordinarily inefficient. They don't get things done. You need a wider basis of deliberation. But it certainly seems to me that the key to this is to have a degree of trust in parliamentary institutions, which at the moment is lacking. And the key to that is for Parliament to be seen to matter.
Thank you. Professor Russell.
Yes, I agree that the data that we have is not very encouraging. But I mean, I would say something perhaps a little sharp here, that if the government really is interested in restoring trust, then it ought to change the way that it behaves and the way that it talks. I don't think you should expect to have a situation where senior ministers are rubbishing the role of Parliament, rubbishing the role of the courts, where there are briefings from unnamed sources, often in Downing Street, that are rubbishing the civil service, that are rubbishing regulators, and then expect to set up a commission which is somehow going to restore trust. The government has a responsibility for maintaining trust, and there's been a great deal of noises coming out of this government that are driving things in the opposite direction to that. And I think there is a very worrying trend. It's been going on for a long time, but it's accelerated recently. Particularly, the rows over Brexit helped it to accelerate, whereby politicians and indeed people in the media see this data suggesting that trust in institutions is low, and see that there are electoral advantages, or maybe in the case of the media, commercial advantages, in joining a chorus of voices which is saying that Parliament is rubbish, that courts are sticking their noses in, politics is broken. I mean, even the Conservative manifesto included words about Parliament suggesting that MPs had been acting undemocratically. Personally, I thought that was pretty disgraceful. It is the role of senior politicians and of political parties to try and maintain trust in our institutions, and indeed try and improve understanding of the way in which our institutions work. And if senior political figures are rubbishing our political institutions, I don't see how they can expect trust to be restored.
Thank you. Lord Lisvane?
Well, I agree with all that, and I wouldn't encourage Professor Russell to moderate her description in any way. I think the behaviour of the government is going to be an absolutely key part of achieving trust. But I would also say that you can't manufacture trust. You can't instruct people to trust things. They've got to be shown to be trustworthy. And so I think the focus has got to be on the institutional resilience and quality of what we have. And if we can improve that and the way those institutions work, then I think people are going to be readier to trust. But I entirely agree that the first steps in this really ought to come from the government, including the contributions which we see regularly from those who are not accountable.
Thank you.
I wonder, just before we go to John Stevenson for a concluding question in this panel, if I could ask, or be cheeky enough to ask for a one-word answer, if possible, from the three of you, as I try to sort of draw together your thoughts. Is it more about the public trust in politics and our constitution and everything else? Is it more about the behaviour of the actors rather than it is for a yearning for institutional change? Which is more important of those propositions, do you think? Lord Sumption.
They're both equally important.
Good. Professor Russell.
I would always say culture and behaviour over structures. If you look around at other countries that have very different structures to us, they're suffering from many of the same problems. So the answer is not proportional representation, elected second chambers, etc., etc. It's a cultural question, I think.
Thank you. Lord Desvain.
I'd agree entirely with that. I mean, over the years, I've been involved with a great many aspirations for procedural and institutional reform. But of course, you can make those structural changes. Sometimes it's very easy to do that. But unless you've got the people who are going to operate those, the machinery in the right spirit, then it's a complete waste of time. So I would go for the actors first.
Thank you. Just quickly from John Stevenson.
Thank you very much. Given the delays in setting up the Commission, and given the fact that we're almost a year into this Parliament and time will pass, and if the Commission is set up, it will take time to report back, do you actually think there is an appetite within government or indeed within Parliament for this Commission and for the reforms that would flow from it? Professor Russell.
Well, again, the first part of that question is one which you would need to ask the government, not ask us. And clearly there have been delays, and clearly we are all saying that if you're looking at fundamental questions, you need to take your time and be careful, not rush things, and build trust in that process. But I don't think that those two things are necessarily at odds, because if we go back to the previous examples, you know, the Royal Commission, the last one that we held, for example, that was not seen as a creature of any one government. It is possible that you could have a long-term detailed review which didn't have to report in order for the results to be implemented by this government before it leaves office. If it really manages to work on behalf of the whole nation, and not be seen as some sort of a partisan exercise with a already decided conclusion, then it should have a long shelf life, and there should be possibilities for there to be action by a subsequent government, even a subsequent government of a different political colour, because, you know, constitutional agreements should cross party boundaries.
Lord Lisvain, given what you said at the outset, do you think there's an appetite in government for this?
Well, I entirely agree with what Professor Russell has said. I fancy that as the realities of setting up and operating this commission and the extraordinary span of what its responsibilities would be becomes more evident, that is going to be quite an inhibition on government. In a way, the independent review of administrative law might well be the canary in the mine, because the government might want to see what sort of thing they're going to create when they do set up the commission. But I don't anticipate anything happening quickly, but I absolutely endorse what Professor Russell says about the ownership being cross-party and for the long term.
Lord Thompson.
I agree. It's got to be bipartisan.
Thank you.
Okay, thank you.
Thank you, John. And can I thank our three witnesses, Lord Sumption, Professor Russell and Lord Desvain from our first panel. Thank you very much indeed for your contribution this morning. And now, by means of this modern technology, we have our second panel, who I'm pleased to welcome, to our former colleague, Graham Allen, and also to Dr. Andrew Blick. And if I could hand over, please, to Jackie Doyle-Price.
Thank you, Chairman. My question to Graham Allen, welcome. Your proposals for a citizens' convention predates the government's commitment for a commission. Can you tell us what concerns with the UK's constitutional arrangements and democracy led you to develop these proposals?
I think our proposals, unlike the licence that was happily afforded to the previous witnesses, are very tight and very discreet. It's about how we get citizens' engagement in any process. And obviously this process has now come through the manifesto process of the government, but also it's referred to in the manifestos of the other three UK-wide parties in their manifestos to a degree. So there's a desire for a review of democracy among the political parties. So we've adjusted our offer, if you like, which we've put to government actually today. We've sent our proposal through to the Prime Minister and to Michael Gove, which is to the government, and it's about how citizens themselves can get engaged in the Commission. It is not about the Commission, it is not about the agenda of the Commission, it is, in a sense, process rather than policies. I think we've all got a view on policies. We could all talk forever about our favourite policies in these areas, but very few people talk about the process. So we've created a process which is beginning with citizens, as anything to do with our democracy should do. Those citizens, and we can explain about their selection and how they're facilitated and how they put their things forward, but they present their views as a gift to the Commission. Then it is entirely up to the Commission what it wishes to do with those views, and then next in the production line up to Parliament and government. No one is telling anybody what to do, but what we've designed, we hope, is a means by which, a process by which citizens can be involved. And that, Jackie, is actually quite new, because deliberative democracy is quite fledgling. It has been around some time, but really the critical mass has developed globally in the last couple of years, where we now do have ways of engaging with people, getting proper selection, getting microcosms of a nation, for example, which we couldn't do 2 or 3 years ago. We can do that now, and there's great experience out there that we've tapped into. So deliberative democracy, if you like, is the next iteration of democracy. If democracy is going to go forward rather than fall backwards, how do we engage citizens? And we hope that our proposal, which is not to sort of take it or leave it, it's an opening bid to engage government and say, have a look at this, what do you think, how can we improve on it? And finally, the reason to do that, I think now, is because in order for the Commission to work, everyone has got to work together on this. We've heard that this morning. There are lots of ways of putting it, but I like to call it a four-legged chair of the Commission, just one of those legs. Parliament is another leg, government is another leg, and the final leg, without which the chair falls flat on the ground, and us with it, is getting the citizens meaningfully engaged. We're not saying that this thing is the be-all and end-all, but we hope to start that conversation and make that a reality so we can improve and maintain our democracy.
Thank you. I mean, at the risk of putting words into your mouth, it kind of feels like we're in essentially the development of democracy has been top down, with gradually giving more and more to the citizens. And implicit in what you said is that we now have tools to engage citizens better. Is that a fair characterisation?
I think so, and I think we, in the modern era, I think we should strive to make our democracy better. I think for 100 years we all worked away, no doubt, at trying to extend the franchise. How do we improve democracy? We haven't now got a steady state democracy. We'll either improve or slip back. What's the next level? What's the next stage? And I think that is not to do yes or no, black or white with the citizens, a sort of enormous opinion poll. It is to engage citizens so that they can make a genuine contribution. And I have to say, I started as a skeptic about this. My view was, were citizens able to do this? It's a very complicated and difficult arrangement, isn't it? Shouldn't we leave that to just other people, maybe members of Parliament only? But then, as a former member of Parliament for 30 years, it was often very difficult to make any impact at all when bills were landed on us, as they still are, by the government. So getting that engagement and finding the processes to do it, I think has been a really big breakthrough. And I think it's essential. If there's a commission on the Constitution and democracy and rights, citizens have to be involved meaningfully in some way. So yes, Jackie, is the answer to your question.
Yeah, and I mean, in terms of getting the citizen engagement, is this really a failure of political parties? Because there was a time when political parties were mass membership organisations. They're not now. Let's be brutally frank about it. You know, the Labour Party was a creature of the trade union movement, which was mass participation, and the Conservative Party used to have, you know, membership running into millions. I think where they're both looking to get hundreds of thousands now. And is that one of the reasons why perhaps the citizens are disengaged from their political class?
I don't blame the political parties because I think they were a product of their time. But what I would blame political parties would be if they refused to go with the times, use new technology in a nuanced way, not a yes-no sort of way, and engage people, which is now on offer, which even when I was a member 3 years ago, it seems a lot longer, we didn't really understand what deliberation was like. We didn't see it, and Andrew and myself will explain that if necessary as we go on. So I think we just need to catch up, and we need to ensure that people feel that they own their democracy, not that they tell people what to do and it has to happen just so, but that you engage in a proper debate. I think when that happens, people feel a part of it, even if, for example, in a jury is a sort of metaphor very often for deliberation, that people can engage in discussion, they can hear expert witnesses, they take their time, they do democracy in good conditions, which, to be honest, we never did in the House of Commons in my 30 years, I have to say, to actually listen carefully, come back again a week later, discuss things. That, I think, is a really good thing. And what it does for political parties, particularly parliamentary parties, is it strengthens parliamentary parties, because Parliament becomes an institution which is often the commissioner of a citizens' convention, as your colleagues in the Select Committee on Housing and Local Government have done a superb report using deliberative democracy on social care, and 6 of your fellow Select Committees have commissioned a report on climate change, which has produced a superb report. We can have questions perhaps later about whether that then translates into action, and I think translating it into action is something we shouldn't leave behind. The deliberation isn't the be-all and end-all, it is the beginning of the process. But I think political parties are moving with the times, Parliament is moving with the times, Select Committees certainly are moving with the times, and it would be good if the Commission on the Constitution, Democracy and Rights moved with the times also, and enabled people to express a view in a meaningful way, which wasn't a command, but was a gift to enable rational discussion later on up the food chain.
Thank you. Just a quick final point. I mean, one of the simple ways that some political figures choose to go in terms of, involving the public is, let's put it to a referendum. And, referendums become an unnecessarily binary choice, frankly, and isn't the best way of making decisions. I mean, what would be your view of that if ultimately we had a system where the Commission would come up with proposals which were then put in that kind of engagement?
I think the Commission is entitled to say how proposals should be put. But if you're asking me as someone who's with the Citizens' Convention on UK democracy, trying to engage citizens in a meaningful, nuanced and sophisticated way, then clubbing issues with a yes or no hammer, I don't think is the way to go, because it doesn't engage a lot of people sensibly. It doesn't allow people to listen to both sides. It doesn't allow them to think and discuss in small groups and come to conclusions. It doesn't allow them to say, that sounds good, but can you also add this issue as well? Have you thought about that? And throughout the planet, there are literally now hundreds of deliberations going on, And what they do, surprisingly perhaps, is they come up with answers that often allow politicians to take the compromise forward. And the best example of that is in Ireland on abortion, where Fianna Fáil, Fianna Gael would never even raise that issue publicly. But enabling citizens to talk about it enabled us as politicians, as it were, to say, it looks to us as though they've come up with something pretty sensible here that we could never have done. We would have been whipped in a particular way. We would have been hit by the media for what we were saying. But a group of citizens representative of the microcosm, which in that case was Ireland, came up with sensible proposals, and they have now found resonance not only in the Dáil, but also in through a referendum as well. So doing it in a steady, slow-cooked politics rather than macked politics, if you like, way, enables a more sensible answer, which can actually do what we're trying to do now, aren't we, in getting the whole of the country back together again and working together and healing some of the wounds. And I think deliberative democracy and this specific citizens' convention to feed into the Commission is a good way to do that. Thank you.
Thank you.
Thank you. And if I take the next question, and Graham and Andrew, please do feel free to answer in whichever order. So convince me. I'm a fuddy-duddy on all of this. Here I am in the grand surroundings of Committee Room 6, perhaps under the misapprehension that Parliament was somehow a sort of citizens' assembly of sorts. So how are you going to convince the likes of me that this proposal isn't in conflict with our parliamentary democracy? How are you going to convince me?
Andrew, do you want to go first?
Why not? I'll do my best to convince you then. If that doesn't work, I'm sure we'll continue the task. I think, as Graham suggested in his previous answer, these mechanisms are not intended as an alternative or a way of supplanting representative democracy. They're actually intended to be supportive of it. So I think my personal view on this is, in many ways, the best body to commission this would be Parliament itself. And we've seen already that select committees have been doing that. So clearly they do not regard it as a challenge. They regard it as a supportive mechanism that actually enhances the capacity of Parliament to be a representative of the people. And that's the way I would clearly look at it. And we did actually hear reference from Professor Russell's very interesting evidence earlier to a line in the Conservative manifesto that described MPs as, and the exact wording is, having devoted themselves to thwarting the democratic decision of the British people. So I'm afraid this idea is already there, that somehow there's a conflict between Parliament and the democratic will of the people. And I think actually this is a more sophisticated way of incorporating the people into a decision-making process in a way that's supportive of Parliament, rather than creates this idea that unfortunately we've had over the last few years, that in some way the people are in conflict with Parliament. So actually this is a way of bringing people back from that situation, bringing Parliament back together with the people, and then also working with government. Because if Parliament and government and the people are all supposedly in conflict with each other, that seems to be a recipe for a very divisive situation. So that's how I would seek to persuade you.
Thank you. And Graham,
if I may briefly, Chair, not forgetting that I was a fuddy-duddy in your chair for 5 years, and although we did many things on democratic reform and the constitutional reform, we never got around to do an effective look at deliberation, and that was because at that time it had not impinged upon the consciousness of members of Parliament in the way that it has now, with Scotland, Wales, English regions, other countries doing examples of deliberation. Jim Fishkin in America, 110 different deliberations globally. Her Majesty's government supporting the Innovations in Democracy programme and doing 3 local examples to show how this can work in specific places in Dudley, Cambridge and Test Valley. So things have moved on, and I hope I'm be forgiven for being a fuddy-duddy in those days, but having caught up a little bit now. But more seriously, I think the key thing here is not that it erodes, as Andrew said, it doesn't erode Parliament. On the contrary, it will allow Parliament to spread its wings and members of Parliament to do the job that they often thought they were elected to do on the back of really good pre-legislative discussion that can take place. And I was one of the inventors of pre-legislative scrutiny, because scrutiny wasn't good enough on bills, and it's still not good enough. Imagine if, and this is a stretch, but imagine if bills were discussed, instead of lying on the table for 6 weeks, let them have a public debate, perhaps properly organised deliberative democracy debate, to inform the bill before second reading. There are lots of possibilities where, if members of Parliament want to grab these opportunities, it needn't be done and commissioned by government. It can be commissioned by Parliament indeed, and produce even better legislation which MPs feel that they own, rather than they're just part of the sausage machine saying yes or no in a very unhelpful way and not facilitating genuine debate.
Thank you. And if I
Are you convinced, Chair? Are you convinced?
Well, I may yet be redeemed. We'll have to wait and see. I will keep considering it. And if I could go on that note to Lloyd Russell Moyle, please.
I just want to kind of. I mean, I'm generally a supporter of the idea, but I wonder if the abortion example that you gave, Graham, a social issue that was around bringing people together on social things that affect them in their day-to-day lives. And Andrew, the argument that you say about it seeming like Parliament versus the people, well, the reality is the people were divided, Parliament was divided. Parliament probably was representing the people better than it's done in generations, in the sense that the country was asunder, and so was Parliament. So are we trying to use a method here in terms of citizens' kind of deliberation that is trying to resolve something that actually has now gone in the past Brexit, and a method that was better used on social issues, not on constitutional issues?
Shall I go?
Yeah, go ahead, Andrew. I'll come later.
Yeah.
On the Parliament versus people, I agree. I think that was the problem, that the public were divided, and in fact remain divided. And yeah, that the reference in the manifesto there was actually from a party which was on the leadership of which, not necessarily all the members of which, but the leadership of which were on one side of that debate, and that's the problem. But I think if the government we've got now want, with their proposal, to actually move beyond that division, which is still there, this is the kind of thing they'd be advised to look at. But if the exercise they're doing is actually going to be a continuation of that division, taking a particular side in that argument and continuing to pursue it, then we are going to carry on having divisions around those fundamental issues. So this is a way of moving beyond those divisions. And I think those divisions are still there. We have left the European Union, but the issues that the whole Brexit issue engaged are still very much there, and the divisions are still very much there. So it's partly a question to Parliament and also to the government: do they actually want to move towards a more genuine settlement that actually bridges some of those divides? If they genuinely want to do that, then this kind of mechanism we're talking about today is a good way of getting there. It's not the whole of the answer, but it's a good way of getting there.
Arguably, the vote is the most divisive thing to give people, because it's one person or another. But I won't go down that track, because I don't believe in it. I don't believe that it is a divisive thing, nor do I believe deliberation is a divisive thing, unless it is used as a last minute, let's throw this in as a last gasp effort to try and solve a particular problem because it's incendiary in the community or across the nation. I think that may have been the problem on referenda, when Mr. Cameron decided a referendum might be the way to find a way out of a difficult political position. I don't think deliberative democracy, and I will fight very hard to stop deliberative democracy being used as that panacea. It is democracy in good conditions, not in panic and desperation. So it can be used nonetheless to solve some very difficult issues that, as I say, the political structure often and the media structure prevents us as politicians from sorting out. So, for example, nuclear power in Australia, but also in South Korea, has been very divisive, but actually was used to try to get, and did in South Korea's case, actually was adopted as a new policy by the government ultimately. Issues like abortion, you can't get anything more difficult as a social policy. Time after time, there is now clocking up smart politics as a way of using deliberation to really find out what people think they could do and we should do, and then handing back the gift to people. I think someone said earlier, people's expectations are raised, and if they deliberate, they're going to demand that what they say is implemented. Only if you don't get the groundwork, the terms of reference right. If you say to people, we are going to consider seriously and respectfully your hard work, then people look at this in a very different way. Rather like members of parliament, if you say we're going to let you do some hard work and then take no notice of you, you'll get a little annoyed. Well, if people say, we may not do everything you want, but it will be a contribution to the debate and we'll pick out the gems as we see them. So somebody has to start that somewhere. And on an issue of democracy that the Commission is looking at, why not start with citizens? That they are meant to own this democracy, let them have their view, and then let it go through the sausage machine. But if you've made a good case, if, as we have offered in this proposal to Her Majesty's government, it is beginning with a national conversation where everybody is involved. We've set the ambition of 10 million founding mothers and fathers of a new settlement on democracy in the UK. If you can engage lots and lots of people and then distill it down into the theme assemblies, maybe 5 thematic assemblies, properly selected, properly briefed, and properly facilitated, where the individuals enjoy the process, and properly fed and watered as well, they can come up with stuff that often in the hothouse of the House of Commons is the very last thing that we're going to do. But give people space and they can help us get to some answers on these very, very tricky questions.
And I think on the particular point of whether it's good only for social issues of the type you referred to, I think it's potentially good for a range of issues that the existing structures are finding it difficult to deal with. So it's not necessarily confined to a particular area. I would like to add also that I would not want to see it used around the debate that could lead to people having rights taken away from them. So I would like to see it used in circumstances where rights could be added to. So I wouldn't want to see the abortion issue reopened for instance, not that this is necessarily on the agenda, but I wouldn't want to see it reopened in a way which could lead to restriction of rights through one of these processes. But I can see that it could potentially be applied in some of those areas and also in other areas as well.
May I just add, Chair, if I may, a brief point. Someone raised the role of the select committees, as well as commissioning, as they have done, some excellent deliberations. In Ireland, and they didn't just cover abortion, they did a lot of other issues too. The Dáil set up a committee that would receive the first package from the various assemblies. So they had a sort of filter. They had a way of looking at this in advance. I would suggest, it's not beyond the realms of possibility, that the Public Admin and Constitutional Affairs Select Committee may be the perfect vehicle for that, or there could be a specially built thing for a special select committee to do that. But I don't see why PACAC couldn't do that job. I don't want to give the chair any more work to do. I've just looked at the agenda, which is enormous. But that interface between the Citizens' Convention and members of Parliament, I think is really important. We've taken that very seriously. We have a small liaison committee of senior politicians and leaders of parties. We also work very closely with the all-party group on deliberative democracy. This is something that will strengthen members of Parliament and will enable them to find a way to process. Our colleague on our board, Ian Walker in Australia, uses the phrase, give us your hardest problems. The ones where your processes can't work, just run it through a citizens' assembly and see what they can come up with. And they can break log jams that, because of our parliamentary dysfunction sometimes, are seemingly impassable.
Thank you, and thank you for the confidence you're placing in this committee. It's shared between all the members. It doesn't just lie on my shoulders, I can assure that. But on that note, could I bring in Ronnie, please, again? Ronnie.
Yeah, thanks, Chair. For the record, I'm a big fan of citizens' assemblies. I think any vehicle which allows citizens to talk to power has to be welcomed. The key to that is making power listen to what the citizens are actually saying. But I'm confused now. I'm genuinely confused between what we're trying to do with citizens' assemblies and what the Commission's going to be doing. Is it a buffer between? Is it a controlling factor? I'm wondering what the panelists think. What should the relationship be between citizens' assemblies and the Commission? And even beyond that, I know we don't have a remit yet, what should the makeup of the Commission actually be as well?
Andrew, should I have a go at that first?
You go first, Graham, why not?
The relationship of the Citizens' Convention to the Commission set up by government is a wholly subordinate one. It is not taking over the functions of the Commission. It is not demanding that the following things must be done for it to be valid. It is citizens gathered together, looking at some of the difficult issues on an agenda to be decided. We have some ideas about an agenda, but that's to be negotiated. That must lie with government. This is their commission. And discussing those issues, coming up with ideas and recommendations, and then handing them over to the Commission. That is, in effect, the end of the process, which involves the Citizens' Convention. But of course, people will maintain an interest. By that point, we hope that there will have been a national conversation. We would hope that the proceedings of the assemblies, the 5 or 6 themes that are selected for ultimate discussion, let's say who pays for politics, if that happens to be one, that people will follow that through, and they will be, because of that interest and excitement in the country, will hope and be reassured at the beginning of negotiations that they are going to be taken seriously and that their proposals will be treated in a meaningful way. So it is, otherwise, if we weren't to do it that way, Ronnie, it would be subverting the whole process. It would be subverting the right of an incoming party with a big majority to set something up on lines that it wanted, and it would be taking away the role of parliamentarians. So we are the beginning of that sausage machine, if you like, but we hope that the content that we come forward with will be so well put together that we would hope that the Commission would say yes to virtually everything that we would put forward. There may be things taken out at a later point by Parliament or by government. That is your role, that is your right. But also, if you're prepared to set up a citizens element, then it is the right of citizens to discuss things openly, transparently, on TV, and actually come forward with some ideas that they think would be helpful to rebuild or evolve our democracy in the UK.
Thank you, Ronnie. Are you done with that, Ronnie, or is there more?
No, I thought Dr. Blake was going to answer as well, yeah?
Of course.
Andrew,
Yeah, just to really underscore what Graham said there, that the Assembly would feed in to the Commission. The Commission would have to be set up along the lines, ultimately, that the government wanted to set it up. I mean, I'm sure there were lots of views coming in the earlier session, and we could offer views on, the kind of things to be taken into account with regards to composition and with regards to terms of reference. But ultimately, that's a decision for the government. And then the Commission, once set up, would take a contribution from the Assembly, which would then be up to the Commission what to do with it. But in all of those decisions, the question that first the government and then the Commission would have to answer would be, how legitimate do we want to be? And the more inclusive we are, and the more of a considered process we allow to take place, the more likely it is that coming out the other end are going to be proposals which actually command legitimacy and actually command cross-party but also cross-UK support, and actually makes it more likely they're going to work in the long term. So what it really comes down to is how inclusive does the government and then the Commission that it sets up want to be, and the extent to which they allow the Assembly, the Convention, to actually influence what it does and actually have a genuine role will go some way towards shaping how inclusive it is and therefore how legitimate outcomes are likely to be. If, on the other hand, they'd rather pursue a more divisive, partisan approach to these issues, that's an option to them. They are in government. That it is possible, but that would have consequences for the outcomes. So it's partly a decision for the government now and in future as to what kind of a process it really wants to run. So in the end, the process we're proposing specifically here will not be the final say. It will be an influence, but it could, if it's set up properly and taken into account, be a very important influence.
So the remit for the Commission becomes even more important now, because it's about how it takes information from assemblies. And we're not trying to water down what the people are saying. We've got to make sure we're not putting obstacles in their way, that they have to be a conduit in some way to formulate the argument, then take it forward to government.
Yes, and that has to be the case because the legislature and the executive will dispose of the recommendations in the parliamentary sense of the word. They will make them real. So that has to be the process by which it happens, rather than, I'm afraid some of the early efforts at deliberation were wish lists. And even Monsieur Macron, who I congratulate on raising the grand débat in France, made the mistake very early on of saying, whatever you come up with, oh, we're definitely going to do that. And of course, things occur that just aren't practical for one reason or another, or because some people are taking advantage of the fact that he said that. So some things weren't done in France. That's not the way to do it. The way we're suggesting it be done is the citizens say what they think. They've organized themselves in ways to come up with good recommendations that are practical, and they give that gift to the legislature and the executive, with the Commission obviously as the intermediary. And if that happens, then I think you'll find that there'll be a lot of consensus maintained throughout the process. And as Andrew says, what is the point of engaging citizens? Please don't engage the citizens at all if it's just to sort of go through the motions, because that will lead to more distrust and more unhappiness. And I know, Ronnie, if I may, that's something that you've tried to avoid with the government in Scotland creating the Citizens Convention, a Citizens Assembly rather, on the constitutional arrangements in Scotland.
Thank you very much.
Thank you very much. If I go to Nav, please, now.
Thank you, Chair. The Commission's remit is to restore trust in our institutions and how our democracy operates. How do you think the Commission could achieve this? Dr. Blake?
Well, I think a first point I'd like to make, as a historian, I think we have to be. We've had some discussion today about the idea of a decline in trust in institutions, collapse in trust in institutions. that has been said before many, many times, and you can go back to even before we properly even had democracy, people were saying democracy's on the way out before it even really been introduced. You can find Oscar Wilde saying it. I mean, so we've got to be slightly careful about making generalizations. So that kind of terminology about restoring trust assumes that there's been a loss in trust. And obviously, again, that wording came out of a particular interpretation, which was saying the trust that's been lost is the trust in those MPs who voted a certain way in certain divisions over a certain issue, which we don't need to go into that today. But I think first you've got to be careful about that and manufacturing a crisis and then using that as a basis for action that, you know, actually is being motivated by other means. So I'd like to insert that. However, I'd agree that it's important to promote and maintain trust in institutions, absolutely. And I think actually this is a good way of doing it. The kind of process we're talking about is showing that we do engage with people in between voting, and that's widely established that we do engage people in between voting and elections. And this is a way in which we can do it. We can put some trust in the people. And also I think it's a two-way thing that actually that it's important to do an expectation management job here. And actually by this kind of process, by taking people through the stages, what are the issues, and actually having proper briefings to them, getting experts, doing evidence sessions, you can actually show them these are the kind of considerations that are at play. It's not a simple issue. There aren't straightforward yes-no answers as sometimes might be presented in a referendum, and actually show people these are difficult decisions to be made. And so hopefully you can build trust, not just by government and parliament listening to people through this kind of process, but also showing to the people and the people observing the process, the wider audience, that these are complex issues, and therefore, you know, we have to part of the trust we have in government is a trust that recognises that government isn't easy and being parliament isn't easy. So I think that's the kind of process I'd like to see. Mutual education really would be a useful part of the task, and also a willingness at the end of it all, because it's been a good process, to seriously take into account the proposals are made and to respond to them in a reasoned way. And if a government or Parliament is not adopting everything that comes out of it, saying why, explaining why. So that's the kind of trust building. So yes, I'm all in favour of building trust, and I think that's the kind of way in which this process could contribute to that.
Thank you, Dr. Blake. I think your point about engaging people between election cycles is very, very important, amongst other things you said. Mr. Allen, would you like to contribute?
If I may, I think going back to that, this should be win-win for everybody. I mentioned the sort of four-legged chair, and that everybody in there has got to sort of support each other as part of building a new democracy. And one of the things about trust, and that Andrew put the citizens' position there, if you like, I'd also like to say to members of Parliament, and I found this very, very difficult, if you trust a group of people to go away on behalf of the country and behalf of this process, and they come up with stuff, I can guarantee you that they won't come up with, in this case, Graham Allen's favourite 20 reforms, or even, Andrew, your own. They will come up with stuff, having had a serious discussion, compromising, working stuff out, seeing how this bit fits to the other bit. And we, if I may say we as a former colleague, we will also have to trust, providing we're confident in the system, and it's up to us to make clear that you should be, they will have to trust those outcomes and say, we see that this was done seriously. We see that they spent more time than we have on that issue, that they've had greater expertise, they've consulted more widely, they've had a bigger conversation, and they've done it in good faith, and that we trust to a greater extent that they are coming up with something interesting and helpful that we can work into a piece of legislation. So even people who've spent a lifetime writing up the ideal answers on whatever it is, a second chamber or this, that, and the other, I've sort of had the revelation of no longer being a policy person, but just being a process person, because getting the process right is what enables those policy decisions to be made. But the downside is they're not always going to be the policy decisions that you personally would want. That's part of having faith and trust in the whole process. And trust begats trust. We have more faith in MPs, we'll have more faith in government, and they will have more faith in people, and it just goes round and round and builds up. And my word, I think that's what we need at the moment in terms of pulling the country together again on some of these issues.
Thank you, Bill. Thank you, Chair.
Thank you. David Jones, please.
Yes, Graham. The Citizens' Convention proposals rely significantly on the public's engagement with the process. Yes. We're talking about clearly constitutional issues, which to many might be regarded as rather dry and not particularly interesting. Why would this process generate more interest in constitutional issues than might otherwise be the case?
David, you're asking the question that was always my favourite question when I began this journey, in a way. But looking around at all the work that's happened and has been done across the planet, people surprise you, and they certainly surprised me in terms of, if you are part of the process where you've put your name forward and you're picked out because you happen to be a person of the right age, gender, geography, and you are one of the people representing the microcosm of the UK, you tend to be someone who has a great sense of civic duty, and you will take your job seriously, rather like on a jury. And even with very complex cases in the legal system on juries, people listen, they ask the right questions, they want to hear the expert witnesses, but they want to be able to make their mind up, and they have that discussion internally in the jury room, let's say. Well, this is done even to a higher standard of probity in order to get your people who will form your theme assemblies as part of this greater citizens' assembly. So those people become very proud of what they've done, they own what they've done, and they will have an interest in making sure that they see it through to the end. Wider than that, though, David, if you see the little graphic that we've done in our proposal to government, which I think should by now have been circulated to all members, you'll see that the Citizens' Convention proper, as it were, sits in this sea of a national conversation, where if we're given enough time, as Andrew says, the more time you give a convention to do its job, the better the outcome. And if we are allowed to engage with media partners, with using the parliamentary channel, with engaging people through, for example, automated mediation, where it's possible now to actually have literally thousands and thousands of people engaged. One of the less frightening aspects of artificial intelligence, where you can get thousands of people engaged on particular nuances of particular questions, then you are engaging people in a wider sense. So it's proven elsewhere, David, and I think there's nothing wrong with the water in the UK that would mean that people in the UK couldn't do this job just as good as they've done in certain states in America, in Australia, in Germany, in Italy, in France, and indeed in China.
You compared the role of the convention to the role of the jury. The jury, of course, is not a self-selecting body. You're summoned to do jury service. In the case of the convention, you actually put your name forward. So isn't there the danger, therefore, that the individuals who put their names forward are people, if you like, who've got an axe to grind about the issue that they're being asked to deliberate on? Is that not a bit of a problem with the process? And before you answered, the other point you made earlier was the need for the convention to be, use the expression, properly selected.
Yeah.
Who does the selecting?
So it is rightly a complicated process, and it's laid out on pages 16 and 17 in the proposal to the government, and still needs further refinement. Government need to be happy with this process, David, as well as ourselves. But to simplify it, and with all the things that arise from oversimplification, if this is taking place, if there's interest in the country, if people are inspired by the debates that are going on, that we will have, that people will do on TV, that people will do online, there'll be people who will say, oh, that sounds quite interesting. Then a seductive invitation arrives, which there are people who make money from doing this sort of stuff, believe it or not, in this field, not selling soap powder, but about deliberation and democracy, engaging people and saying, we can't promise that you will be in the final selection because there may only be up to, say, 400 or 500 people covering the whole thing, and there are millions of people interested. But would you be interested? Because we are seeking to make this a representative microcosm of the UK. Then people can say yes or no. They think probably they won't get drawn out of the hat, so to speak. But then there's another complicated process which makes sure that every nation and region, age group, gender of the UK is properly represented in that final group. And then there's a number of substitutes should anybody drop out because of births, deaths and marriages. So it is done with the utmost propriety. It is done openly and with integrity by people who are expert in this field. So it's actually much more rigorous, in my opinion, than jury selection. And you will get people who are quite surprised to be drawn out, maybe a little bit taken aback. There's some wonderful video from the Irish example where people arrive on the first day and saying to camera, oh, what on earth am I doing here? I bet they're all professors and, you know, people with master's degrees and stuff. And actually, no, they're people like you. And you get to know people at your table, you get to know about them and their history. And apparently they form strong friendships thereafter, which outlast the actual process. So it is done very, very carefully. If it weren't, we would be wasting our time if that wasn't a process of high integrity. But the final check of reassurance is that none of this will move unless government, who will commission a citizens' convention through the commission, are happy that the standard is the highest possible standard to select the people to help us through some of these very difficult questions.
And just to add it, what is obviously the case that we wouldn't be able to make people to take part, and so it would be people who wanted to take part, but we would be seeking people from a range of groups, including social groups that don't normally take part as much as other social groups, and we'd have a range of measures in place, for instance, childcare support, things like that, for those people who might otherwise not be able to take part. So that would clearly be an objective. And I suppose any political process involves people who want to take part. So in that sense, it would be no different. You know, I know in Australia, they may have compulsory voting. We don't have things like that here, other than for jury service. So it wouldn't be any different to any of those other processes, only we would be paying special attention to the fact that we wanted a balance of different groups that was representative of society as a whole.
Just to add, that Parliament itself did this process, David, on the social care question with the two select committees, and it's also done it to a very high standard, engaged Involve, the organisation that did a superb job on the Climate Change Assembly. So there are standards, very high standards already set, and they must go even higher and not slip.
You mentioned President Macron's faux pas, where he promised to deliver whatever the convention recommended, and then realized that that was really not a particularly wise thing to do. But isn't this the problem? If there were, as there would be, wide public engagement in the process, but the recommendations were not seen to be implemented, might this not act as a discouragement to people or to the public who are already alienated very much from that political process?
If it was done that way, yes, and that would be destructive of the whole move towards deliberative democracy. So it must be done at the outset with complete honesty and say to people, you will produce, we hope your representatives effectively in this microcosm will produce some excellent ideas, but they will be hard won. They will be the result of discussion, of compromise, and as a result of that, with looking over our shoulder, lots of good friends in Parliament, making sure as observers that the process is done in absolutely the best way. But we are telling you now, you haven't got the right to change the law, even if you put a recommendation forward. Equally, saying to government and the Commission, you haven't got the right to destroy deliberative democracy by just totally ignoring and steamrolling over something that has been out there on television. Everybody's been trying to get engaged online. Lots of people have been tuning in to see how the convention is working. You have a responsibility to look after that newfound interest in our democracy that we are protecting and blowing gently on that candle so that it can grow and develop. So again, David, it's as I said earlier to Navendra, that this is something where we hope these are trust-building measures which, bit by bit, they're doing their part, they're being fine with us, they're treating our things seriously, and everybody starts to get better and get more out of this process. It should be, if we're all fair with each other, win-win for the institutions like Parliament and government, but also for the citizens as a whole who will see that their ideas have been taken seriously, and many of them, if done properly, will be incorporated hopefully into law ultimately.
Thank you very much.
Thank you very much. And with that, can I thank Graham and Andrew for your contribution? And,
thank you.
And pledge to approach it with a fairer mind than perhaps my initial questioning gave to you. But thank you both very much indeed, and also for circulating the document with members of the committee. That's extremely useful. And can I conclude by thanking all